Hello, Yoni Markov here from Elder Solutions Law Firm. Wanted to take a couple of minutes and just discuss with you the idea of an estate plan. The first is, what exactly is an estate plan? Well, it's a set of 5 documents that control or help to control your life, both health wise and financial, should you not be able to control them yourself, either because you're incapacitated or because if you passed on. So those 5 documents are a power of attorney, healthcare surrogate or healthcare proxy, a living will, and a trust. All right, let's unpack this for a couple of minutes. So a power of attorney. Power of attorney allows the person or the attorney in fact to step into your financial shoes. That means that the person or the attorney in fact would be allowed to handle any financial transaction that you currently do yourself. That's banking, IRS, Social Security, other government agencies, your stock portfolios, your financial advisors, real estate transactions, all of your aspects of your life that touch upon your finances, the attorney in fact can handle. There's essentially 2 types of powers of attorneys. There's a limited and a durable. So a durable takes effect now. As soon as it's signed and notarized, it is in effect. A limited can be limited to a certain type of transaction, for instance, such as real estate, okay? Or it could be limited in that 2 independent physicians need to sign off that you're incapacitated. Incapacitated meaning you don't have the ability to handle it yourself. Why would we do a limited? Well, if you imagine that you're otherwise okay, but you have a real estate closing because you're selling your house and you're going on a cruise and all the paperwork needs to be signed, we could do a limited power of attorney just for that purpose. Healthcare surrogate or healthcare proxy is the same, it acts the same way as a power of attorney, except that it touches only upon your medical care. So if you imagine that you're incapacitated and a medical decision needs to be made in terms of doing A or B, that's where the healthcare surrogate healthcare proxy kicks in. We have also a living will, which is not a DNR. It's a do not resuscitate is different than a living will. Okay, do not resuscitate needs to be done on yellow paper, needs to be notarized. And the one problem with the DNR is that you now need to walk around with it in case there's an accident, because you never know when you're going to need it, and hope that the paramedics find it in your glove compartment, in your purse, in your wallet. It's a little more complicated than just simply having it. The healthcare workers need to know that it's in existence. All right, so a living will. Living will is, to use the legal terminology, if you are in a permanent vegetative state. What exactly does that mean? If you're in a coma and there's really no chance of you coming out of the coma, do you want to remain on life support? Sometimes it could be breathing apparatus, that could be feeding tubes, whatnot. And the question on a living will is whether you want to remain on life support or not. That's a living will. It's not a DNR, and it's different than your will. Okay, what is a will? Well, a will is just simply a listing of your assets and who it goes to, who you wish to inherit your assets. So, for instance, if you own a home and you have 3 kids, you might say in your will, well, I want to divide the house, sell the house and divide the proceeds equally between my 3 children. Okay, fantastic. Common misconception: a will does not avoid probate. Okay, why is this important? Well, it's important because probate is an expensive and a long process. It's a year plus to get through, and it's 3% of the value of the assets. So if you imagine your entire financial picture of a home, life insurances, maybe some pension plans, your bank accounts, it's not hard to get up to, say, $1 million. Well, at 3% for $1 million, you're looking at $30,000 of fees for probate. And it's going to take a year plus to get done. During that course of the year, guess who has to pay the real estate taxes, the insurance, the pool guy, the lawn guy, the electrical, all this stuff needs to be handled during the course of this year. So for that reason, we really do want to avoid probate. How do we avoid probate? It's a very simple process. We avoid probate by creating a trust. Okay, what exactly is a trust? Well, a trust operates much like a will does in terms of these are my assets, this is how I want it distributed. Okay? But it goes a little bit further than just a will. The first difference is that it avoids probate. I can't say this enough. It avoids probate. The second difference is the cost. Cost of probate, for $1 million is $30,000. We're looking at a tenth of that to do an estate plan with a trust-based, what we call a trust-based estate plan. Where else is it different? Well, we differentiate ourselves based on our knowledge and our trust themselves. So for instance, our trusts have contingencies built within it because we can never know exactly what's going to happen in the future. So I try and have a belts and suspenders and include all different aspects that we could possibly think of. So for instance, if one of your beneficiaries has a horrendous car accident 3 years later, okay, and now they're going to inherit, their inheritance, but yet they're on Medicaid because they're disabled, guess what? They will lose their Medicaid. So what do? We create special needs trusts built within the revocable living trust itself to avoid these issues. Okay? We also, if you have minor children, these are things that we need to discuss and figure out how we're going to distribute. Meaning, everybody says, oh, I have 3 kids, so everything gets divided a third, a third, a third. All right, imagine a scenario whereby the oldest child is 24, graduated college, the middle is 20, and the youngest is 16. Okay, is equal really equal? What I mean by that is you, as a parent, paid for college for the 24-year-old. Well, guess what now? And for half of college for the 20-year-old. Well, guess what happens now if you pass away? If we say everything is equal, the 16-year-old has to use their inheritance to pay for their college, where their 2 older siblings was paid for out of your income, which is no longer there. So for that reason, equal isn't always fair. And these are discussions we have during the design phase of the estate plan. We go into these types of details with you. If you have minor children, we also do guardianships, pre-need guardianships for the minor children, so that if you and your spouse were to pass away, the question becomes, who's going to take care of the kids? You don't want to have the 2 families now fighting in court about who's going to be the guardian of the children. This is why we go into depth and into details with this stuff, so that you can rest assured that this is taken care of should you not be here. So that is essentially what an estate plan is. We welcome phone calls. We welcome discussions. If you have any questions, please feel free to call or email us. Thank you and have a great day.